Good morning, everyone, and welcome to Legal Link's digital asset session focusing on legal and practical developments in cryptocurrency and blockchain technology in the UK. I'm Julia Charlton at Charlton's Law in Hong Kong, co-chair of Legal Link's FinTech group, and I'm seriously excited to be your moderator today. I've spent many years advising in corporate finance, and the most interesting development in my career in years has been this amazing space of crypto and blockchain. And it's fascinating to see how regulation is expanding both in Asia and in the UK, as well as, of course, across the rest of the world. Legal Link is an international network of over 70 independent business-orientated law firms with members in most of the world's key financial centers and commercial centers. And we have over 4,000 legal professionals altogether. So the importance of today's topic can't be overstated. The global cryptocurrency market reached a staggering nearly $4 trillion this year already, with daily trading volumes hitting over 144 billion dollars. In Hong Kong, the crypto market is projected to reach a volume of 68 million dollars this year, with around 400,000 active users. That's over 5% of the population. But with this growth comes serious challenges. With exact figures for 2025 crypto crime still emerging, Chainalysis noted that illicit transactions dropped to 0.34% of total on-chain volume in 2023, suggesting a decline in overall crime, but with sophisticated threats persisting. For instance, cross-chain obfuscation techniques, often linked to state actors like North Korea, accounted for 12% of this activity in 2025. Ransomware payments have also hit record levels, with demand soaring as high as 2.2 million per incident recently, making this a pressing issue for legal and compliance professionals. In the UK, the Financial Conduct Authority reports that 12% of adults, around 6.1 million people, owned crypto assets in 2024, with an average holding of about £1,800. English courts have been busy handling over 40 crypto-related cases in the past 2 years. And Hong Kong, where I am, is cementing its status as a global crypto hub, with 86% annualized growth in crypto transactions and 9 licensed virtual asset trading platforms at the moment. So change is happening worldwide. So to really hear the in-depth story about this, we have two excellent professionals with us today. David Bowman, Legal Director at Waitmans, and Steve Sanford, Partner in Digital Forensic and Incident Response at Sykecell. So let's talk a little bit first about Steve's amazing CV. Steve is a partner, as I've said, in digital forensics and incident response, and he leads his firm's global response operations. He's got nearly 2 decades of experience in digital forensic and cybersecurity, and he specializes in investigating and advising on complex cyber incidents across multiple jurisdictions. He's worked with organizations of various types and sizes to respond to their incidents, assess their readiness for these events, and support the evaluation of infrastructure, policies, and procedures. He assists in developing workflows and internal capabilities, and he's led numerous cybersecurity projects, ensuring they're delivered on time. He provides strategic guidance throughout the incident life cycle. And prior to joining Sykecell, Steve held a leadership role at Ankura Consulting, where he built and led cyber response teams. He is amazingly good at sharing his knowledge, and he enjoys mentoring and training others in his field. So we're going to really look forward to hearing Steve's insights on what's really going on in the world of cyber currency investigations and crypto crime. And we also have David Bowman, who is an extremely accomplished lawyer. He is a legal director at Waitmans, a very major UK law firm, and he's based in the London office. And he has a wealth of experience and background, as you would expect, in contentious issues. He's specialized in group actions, banking and financial services, litigation, commercial contract disputes, and he's dealt with asset recovery and recently jurisdictional challenges in blockchain related cases. He's handled cases before the Supreme Court, the Court of Appeal, and the Business and Property Courts. And his impressive client list includes international banks, a large multinational IT company, publicly owned passenger railway network in the US, major flag carrier airlines, as well as PLCs and local government in the UK. He's been recognized as a recommended lawyer in the Legal 500 rankings, which is an international lawyers ranking. He's got many notable cases throughout his career, but I'm going to leave it to David himself to talk a little bit more about some of the interesting cases that he's been involved in recently and at the moment. So without saying more about that for the time being, I'll hand over to David, who's going to talk about an introduction from a legal perspective of the fundamentals of digital assets and blockchain. And then he's going to hand over to Steve. And then we will deep dive into discussions and conversations and for everybody joining. So over to you, David.
Thank you very much, Julia. As Julia pointed out, yes, I've had the benefit of some experience of litigating crypto cases. One from that springs to mind from 2020, which was the first multi-million-pound house purchase in England and Wales using only crypto, which was an interesting experience and a first taste of the world of crypto assets for me. That was a piece of litigation that lasted a few years. And more recently, I'm acting in a major fraud case arising out of the Himalaya exchange, the Himalaya coin fraud that emanated out of the United States. And that's involved all sorts of very interesting points of law. But let me move us along to the beginning of my talk. Thank you again, Julia. It's great to have so many colleagues from around the world on the line today. Welcome to you all. This presentation will assume a certain amount of basic knowledge about cryptocurrencies and crypto assets generally. It's not intended to be a primer on the subject, and I intend to give an outline of where the law of England and Wales has arrived in relation to cryptocurrencies. I'll touch very briefly on the regulatory situation at the end, but if there is demand, we can do a further webinar on that topic in particular later. So what are crypto assets? Well, the Financial Conduct Authority, and the Financial Conduct Authority, the FCA, is the UK's financial services regulator. It regulates how financial services, including digital currencies, are promoted and sold and who can sell them. The FCA defines crypto assets as cryptographically secured digital representations of value or contractual rights that use some type of distributed ledger technology, DLT, and that can be transferred, stored, or traded electronically. Let's have some fast facts for you. So in the first half of 2025, the volume of stablecoin transactions alone accounted for $4.6 trillion across 1 billion transactions. 4.6 trillion is approximately the gross domestic product of Germany over 2024. So these are astronomical figures. In late 2024, the FCA reported that 12% of all adults in the UK owned cryptocurrency with an average value of just shy of £2,000. In reality, that latter figure is an average. There are, although the 12% hold some sort of crypto, some hold hugely valuable portfolios, whereas others have much more modest accounts. In the first year of regulating the promotion of cryptocurrencies, which was 23 to 24, the FCA issued 1,702 public alerts, removed 900 scam cryptocurrency websites, and had removed 50 fake apps from mobile phone marketplaces. Globally, business-to-business trading of cryptocurrency has increased from 100 million per month in 2023 to over 3 billion a month this year. And with all this activity going on, it's no surprise that major e-commerce businesses like Amazon and Walmart and others are developing their own cryptocurrencies to improve individual transaction profitability by removing the middleman and saving on bank interchange and credit card processing fees, which would otherwise drain tens of billions of dollars from their bottom line. So perhaps some basic terms of art that it may be useful to define or clarify at this point. What is a stablecoin? Well, a stablecoin is a cryptocurrency that aims to maintain a fixed value by reference to another currency, commodity, or financial instrument, something that we call pegging. Examples are Tether, which is a US dollar token stablecoin, URC, which is a euro coin, and Pax Gold, which is a coin that is pegged at 1 ounce of gold value at any point in time. What is a private key? And a private key is the encrypted password, that is the extremely long series of characters, which allows the transfer and proof of ownership of cryptocurrency tokens. This is the key to the lock that enables these assets to be moved from one place and one person to another. A public key is a public address that is used to send and receive the cryptocurrency transaction. It is a key to identification, and as I've said earlier, half of the equation that is needed to create these digital assets. What does on-chain mean? Well, that's the status of a transaction that has been properly recorded on the distributed public ledger, i.e. it is almost like the public registry of ownership. What is a wallet? A wallet is a digital storage location for keeping the personal encryption key secure, and there are a variety of different wallet providers. What is an exchange? An exchange is a website or an app that allows users to buy or sell cryptocurrency assets, i.e. it is a service which facilitates the sale of tokens and the registration of transactions on the blockchain. They are a linchpin in the general customer's experience. White paper is the technical document or prospectus released alongside the cryptocurrency or the exchange, which explains how that particular coin or trading system works. So, where are we in England and Wales with regard to these assets? What is the legal status? Well, it all started with a legal statement in 2019 from the UK Jurisdiction Task Force. Now, this is a task force that is started by the UK government's Law Tech UK initiative, and it consists of a panel of academics, data scientists, and lawyers with the support of the judiciary to flesh out where this bleeding edge technology falls with regard to the law. And in 2019, they released a statement which made the following conclusions. Firstly, that crypto assets have all the indicia of property. That is, they have all the major features of being a form of property. The novel or distinctive features possessed by some cryptocurrencies, their intangibility, cryptographic authentication, use of a distributed transaction ledger, their decentralization, the rule by consensus, does not disqualify them from being property. But the private key is not in itself to be treated as property, because that is actually mere information. It's worth pointing out that the approach to crypto assets in my jurisdiction of England and Wales is somewhat different to the approach that other jurisdictions have taken. And you may be asking why a task force is sort of going over the old law to find cause for the existence of this form of property rather than just legislating for it. And Geoffrey Voss, who's the Master of the Rolls, the head of civil justice, the judiciary in England and Wales, said in a speech when this paper was launched that other jurisdictions have addressed the problem differently. In many cases, they have started from the standpoint of regulation and remedies and worked backwards. Our objective in the UK Jurisdiction Task Force has been to start from the basic legal principles and to work forwards to regulation and remedies. There is no point in introducing regulations until you properly understand the legal status of the asset class that you are regulating. Likewise, one cannot consider what remedies ought or ought not to be available until one has the same underlying understanding. So that's sort of informs the difference between how we do things in England and how other Hong Kong or Singapore or even the United States have addressed things. The first case to really come forward on crypto is the High Court case of AA versus Persons Unknown, which happened a few months after the release of the legal statement in 2019. And as you can see there, it was an application for a proprietary injunction over property, and claims for restitution and constructive trust concerning Bitcoin. The judge in that case noted that it is fallacious to proceed on the basis that the English law of property recognises no forms of property other than things that are in possession or things that are in action. Essentially, and for the reasons identified in the legal statement, I consider that a crypto asset such as Bitcoins are property. They meet the 4 criteria set out in the leading decision there that I won't go into. But those indicia that were mentioned above were as follows: that the asset class is definable, identifiable by third parties, capable in their nature of being assumed by third parties, and having some degree of permanence. So moving along after 2019, the Law Commission, which is the public body which advises government and parliament on law reform, introduced a digital assets consultation paper. And in that paper, the Law Commission concluded that the law as it was in England, and indeed as it still is, can accommodate these digital assets without needing specifically fresh primary legislation to bring them into being. However, there was sufficient doubt over certain aspects of it, and perhaps the blurriness of the boundaries of this technology, that the Law Commission recommended that a piece of legislation be introduced to confirm that this category of asset and property existed. And again, they put forward a draft bill which was to be introduced into Parliament if the parliamentarians wished it, which would effectively create a third category of personal property, one that is not something that one holds in possession or a right to do something, but a digital form of asset. And the bill, which is now known as the Property, Digital Assets, etc. Bill, which has gone forward through the House of Lords procedure, has not yet been enacted, but is on its way, is very short. And all it says is the following: a thing, including a thing that is a digital or electronic in nature, is not prevented from being the object of personal property rights merely because it is neither A, a thing in possession, nor B, a thing in action. So effectively, creating a third category of property by virtue of saying that just because it is not A or B does not mean it is not C, albeit C is not defined in any way. So these 7 cases that I'd like to just summarize for you today are the main, most significant cases concerning crypto assets that have come before the courts so far. You'll note a few things about this list. Firstly, there's a lot of persons unknown in crypto case law, and that goes with the anonymity that is inherent in crypto assets. But it's also a reflection that most of the case law that has been heard so far arises from fraud, where the fraudsters are persons unknown. Secondly, aside from the Tulip trading case there at number 3, all of these are first instance decisions. In fact, most of these cases have not even gone to a full trial. They are, in the large, summary judgments and judgments from return hearings for injunctions. And that is, of course, a factor that arises from the relative novelty of the technology and becoming far more and more widespread as time goes on.
So I'd just like to go through each case briefly and show you what it was about and what the implications are. Deloya and Persons Unknown is a case of the High Court Chancery Division. Mr. Fabrizio Deloya, an Italian engineer and founder of Microgames, defrauded of significant amounts of cryptocurrency, including Tether and USD coins, through a sophisticated scam involving fraudulent online platforms. Court considered whether it could grant a proprietary injunction, that is a freezing injunction or an injunction that the court orders that something be done with the property, and that it permits service of proceedings via unconventional means, such as through tokens that are imprinted in the blockchain and dropped into the wallets of the fraudsters. This is known as airdropping. The court's decision was that the injunction could be ordered against Persons Unknown because, and reflecting this asset was property, and allowed for service of court documents via NFTs, non-fungible tokens, which were airdropped into the digital wallets. The court reaffirmed that crypto assets are property under English law and can be the subject of legal remedies. But again, this was a first instance decision. It's a significant case because it was one of the first fully heard cases involving crypto assets, and it demonstrates the common law's adaptability in using innovative methods to address the challenges posed by anonymous and decentralized blockchain technology, and how, for instance, one brings the existence of a court order to the attention of the targets of that order. And for businesses, it underscores the importance of prompt action. Case number 2, Iron Science Limited of 2020. So we're going back in time a little bit. This is a commercial court decision, again, part of the High Court in London. Iron Science Limited and its director were the victims of an ICO fraud, losing approximately £577,000 worth of Bitcoin and Ethereum, Ethereum being another one of the major trading coins. They were misled into investing into what they believe was a legitimate cryptocurrency venture. The claimants sought a proprietary injunction and a worldwide freezing order against unknown defendants. They also applied for bankers' trust orders against cryptocurrency exchanges to obtain information aiding in the identification and recovery of the assets. Commercial Court granted the proprietary injunction, a freezing order, and disclosure orders. Again, the court recognized that crypto assets are property and that it had jurisdiction to grant these orders against Persons Unknown and to serve them out of the jurisdiction. Again, an example of the English court's assertion of worldwide jurisdiction. The case highlights practical legal strategies of businesses victimized by crypto fraud, and it emphasized the court's willingness to support victims through the remedies. The targeting of crypto exchanges for remedy arising out of frauds is a very special area of interest for litigators. It is, an exchange is in many ways a rock in a stormy sea, a point of relative calm and fixture against which some sort of claim can be brought in circumstances where you may not know or have any awareness of how to get to the individuals who actually perpetrated the fraud. So litigation against exchanges, I think, is an area to watch. Tulip trading. This is the Court of Appeal case. There was a lower court case, but this is quite a famous case because it involves a serial crypto asset litigant, Dr. Craig Wright. Now, Dr. Craig Wright is most infamous for claiming to be none other than Satoshi Nakamoto, and many of you may be aware that Satoshi Nakamoto may or may not be a real person, but it was the originator of Bitcoin and the individual, some say genius, who created the fundamentals of crypto assets as we know them today, over a decade ago. And that claim was found to be dishonest in other litigation, the Crypto Open Patent Alliance cases. And Dr. Wright has been committed for contempt of court and sentenced to 2 years suspended sentence for that contempt. So
you have to, I think, read this decision in that context. He claimed a loss of access to approximately 111,000 Bitcoin, which at the time of the litigation, the original litigation, was worth 4 billion, but now is hugely higher than even that enormous figure. And he claims that he was the victim of a hack. The company argued that the developers of the Bitcoin network owed a fiduciary and tortious duty to assist a victim to regain control over assets that had been lost as a result of a fraud. So you can see that is a significant point of principle. And the issue really is, do the developers of a decentralized blockchain network, such as Bitcoin, owe a fiduciary duty or duties of care to owners of the assets on that network? The Court of Appeal overturned the High Court's dismissal of that claim and allowed it to proceed to full trial, because the court found that, in fact, there may well be a serious issue to be tried regarding the existence of such fiduciary duties between the developers and users of the crypto system. The implications are that the case should be closely watched, as its outcome could significantly impact the responsibilities of blockchain developers. A ruling that developers owe fiduciary duties could alter the dynamics of blockchain governance and impose new obligations on those who maintain and update blockchain protocols. Such an outcome would likely push developers into an even further into secrecy, and that would raise practical problems for any claimant. However, as I've noted above concerning the fate of Dr. Wright, it is unclear whether the case will ever see the inside of a courtroom again, and indeed it is not exactly clear whether the case has actually been settled. But certainly, given the Court of Appeal's decision to allow the appeal and to have the case tried, it is suggestive that this is going to be fertile ground for further cases in future. Case number 4, Piruzada, High Court case 2023. Mr. Piruzada was defrauded of approximately 870,000 USDT, it's a stable coin, through a murky cryptocurrency investment scheme. And he was induced to participate in, and these individuals he could not identify. He sought a freezing injunction against Binance, and Binance is a very well-known exchange, probably the biggest. And he alleged that they held stolen assets and were under a duty to prevent their dissipation, so similar to the Tulip trading case. The court examined whether it had jurisdiction over Binance, as Binance was a foreign entity, and whether a freezing injunction was appropriate in the circumstances. The High Court in this case discharged an earlier freezing injunction against Binance on the return date, and the court found that it lacked jurisdiction over this Cayman Island registered company and noted the challenges in establishing connections sufficient for the English jurisdiction. So the case highlights the jurisdictional hurdles in crypto asset recovery, particularly when dealing with the entities operating outside the UK, as many developers and exchanges are notionally at least based offshore. For businesses, it underscores the necessity of understanding the legal jurisdictions involved in cryptocurrency transactions and the importance of considering these factors when engaging with foreign exchanges. It's also a lesson in doing your due diligence when you're transacting, because Mr. Piruzada was unable to identify any aspect of the persons unknown in that case. Muij versus Persons Unknown 2021 case. This was unreported, but was a High Court case. Mr. Muij was deceived into transferring 20 Bitcoin and 330,000 euros to fraudulent entities posing as legitimate investment platforms. And this was a summary judgment application against Persons Unknown. The court considered whether it could grant final relief, such as a money judgment, against the defendants who were not known to the claimant, which is a common scenario in crypto asset fraud. The High Court granted summary judgment and continued freezing orders against the unknown defendants as potential newcomers to the litigation, because at some point in the future they would be forced to identify themselves to cash out their illicit gains. And this is by virtue of the fact that their identities could potentially in the future be ascertained from their wallet and the public key that was used. The implications are really that the case demonstrates the court's application of injunctive relief developed in other settings, and indicates that the English courts are willing to accommodate the unique challenges of pursuing legal action against anonymous parties. Just as a point of a comparison, in the case of Bunyam, the court declined to give that sort of injunctive relief because the individuals involved in that fraud, or at least some of them, may never have been known, and a distinction was drawn between individuals who had caused the fraud to take place who may never be known, as compared to the individuals who held the wallets into which the ill-gotten gains of the fraud were transferred, and injunctions were ordered in respect of that latter group. Joseph Law, again, a commercial court case in 2023. Mr. Law was defrauded of significant cryptocurrency amounts and sought remedy, including freezing orders and enforcement actions involving Huobi Global Limited, who are a major Chinese-based cryptocurrency exchange. The enforcement of judgments against assets held by foreign entities and the extent of cooperation required from cryptocurrency exchanges was an important feature, but perhaps the most important was whether an exchange could be ordered to liquidate crypto assets that it is holding as a custodian into fiat currency to make the claimant whole in monetary terms. And the court ordered Huobi to transfer the frozen assets into England and Wales first to facilitate the enforcement, highlighting the necessity of exchange compliance with court orders. So in this case, it did in effect order the sale of these assets, and indeed the transfer of the proceeds of that sale into this jurisdiction, which is not unusual in other forms of asset, but as far as I'm aware, the only case in which cryptocurrency has been effectively transferred into this jurisdiction. The case underscores the importance of cooperation from cryptocurrency exchanges in legal proceedings and the enforcement of judgments. For businesses, it emphasizes the need to engage with reputable exchanges that have skin in the game, that are responsive to their legal obligations and the potential complexities in recovering assets. It is a significant feature in litigation against exchanges that those exchanges which are reputable, those which want to grow in major commercial jurisdictions such as England and Wales, and who do not want their reputations or the confidence of their investors hit by non-compliance with court orders. This is effectively the lever that a claimant litigant would have against a major exchange of that sort. And it's obviously very important from their own reputational point of view to make sure that they remain squeaky clean, especially as we are moving into a more regulated environment. And seven, a case from this year, Jones, again, persons unknown. The respondent was defrauded into investing into cryptocurrencies, purchasing 90 Bitcoin through a fake account controlled by fraudsters. After discovering the scam, they hired legal and investigative help, such as my colleague Steve, although he wasn't involved, which traced the stolen Bitcoin to a wallet, which was called the T-Wallet, controlled by defendant number 4. The respondent obtained a court judgment against the fraudsters and defendant 4 and ordered them to return the 90 Bitcoin. None of the defendants appeared, but D4 eventually complied with the court order and returned the Bitcoin along with interest and the legal costs they had been ordered to pay. The cryptocurrency exchange itself, who held the wallet, applied to set aside this judgment, even though it was not a party to the original proceedings. And the reason is the defendant 4 had satisfied that judgment by transferring the Bitcoin from a different wallet, the R wallet, and then reimbursing itself from the T wallet, which did not just contain the respondent's stolen Bitcoin, but held mixed funds, including Bitcoin belonging to other customers of the exchange. So, did the cryptocurrency exchange have the right to set aside a judgment on the basis that it had caused it loss and it had not participated in the litigation? Well, the decision was no. The test to be satisfied was whether the exchange was directly affected by the original judgment. And the exchange was only indirectly affected because defendant 4 had satisfied the judgment using Bitcoin from another wallet that it was the custodian of. These actions were choices that were made by defendant number 4 and were not the consequence of the court's order. Defendant 4 did not need to use Bitcoin belonging to the applicant to comply with the judgment. And so if the exchange had any claim, it was against defendant 4 and not against the original victim of the fraud, who was the beneficiary of the judgment. And even if the applicant had been directly affected, the applicant itself had no interest in this Bitcoin. It was essentially the custodian on behalf of others, and it had not shown any actual loss to itself. The judgment did not order transfer of the Bitcoin belonging to the exchange, and there was a significant delay in bringing the application. So, just as a matter of principle, this application shows the risks of exchanges meddling in litigation between victim and fraudsters, even those that are unknown. So, some concluding observations from all of this. The law of England and Wales recognises ownership of crypto assets, tokens, as personal property. The courts are prepared to extend injunctive relief to defend that personal property. There are practical difficulties in giving effect to that relief, but the courts are innovating relatively quickly. All the cases are first instance at the moment, bar the Tulip Trading case, but there is very little appellate court treatment of the law, and nothing yet from the Supreme Court. However, given the Digital Assets Bill and given the legal analysis and work that's been done to date, it's not likely that the Supreme Court or any other appellate court would be able to pull the rug fundamentally from under the whole crypto asset scene. An increasing number of cases are going to be dealt with by arbitration, especially those directed at the exchanges, and you'll have to look into the terms and conditions and the contracts with those exchanges, the terms of business, and indeed potentially even the white papers. And you need to look out for exotic and strange jurisdiction clauses and governing law clauses involving jurisdictions that are based in the middle of the Pacific, or in some cases San Francisco, where the law is both different and perhaps not as helpful to victims as it is to businesses. And finally, on this point, the Economic Crime and Corporate Transparency Act of 2023 in the UK specifically provides for the extension of the ability for law enforcement authorities to seize, confiscate, and realise crypto assets that have been obtained through unlawful indeed criminal means, and that's been in effect since November of last year. And finally, briefly, as I alluded to, although I don't want to go too far into the regulatory developments, this slide shows a roadmap from the FCA as to the journey it is currently on to become the sole regulator of the crypto asset sector in the United Kingdom. As you can see, we are in the sort of summer period here of 2025. The two main areas of development at present that I think are noteworthy for the purposes of this presentation are that the FCA has approved the sale of crypto exchange trade notes, so-called CETNs, so that investors can indirectly own crypto assets as an indexed investment. And this may give rise to the likes of pension funds and other institutional investors owning crypto through these indirect means. And that's likely to hugely expand the values and the amounts and turnover of these transactions. And we also now have a draft of the FCA's stablecoin regulations, and this stablecoin regulation is going to be the first area of cryptocurrency that is properly regulated up until this point. Only the promotion of crypto assets has been fully regulated. Everything else has essentially just been banned. But this will open up the floodgates to the promotion of stable coins and ownership in 2026. And if you've travelled into London recently, you will have seen a lot of billboards and a lot of advertising going on for stablecoin investments. And that brings my part of the presentation to an end. I'll hand over now to Steve, who can talk to you about the practicalities and technical issues that are arising out of crypto assets.
Thank you, David. So the rapid expansion of the cryptocurrency market has created opportunities for both legitimate innovation and illicit activity. As digital assets become increasingly integrated into the global financial system, law enforcement agencies, compliance teams, and investigators face sophisticated challenges in tracing, analyzing, and prosecuting cryptocurrency-related crimes. This part of the presentation will examine the current landscape of those cryptocurrency investigations. So again, just some basic glossary terms, and apologies if some of these duplicate what David covered, but I feel that it's important to hammer home and to understand all the terms related to cryptocurrency and the blockchain. So the blockchain is a digital ledger that records transactions in linked blocks shared across many computers. A block is a group of transactions that are bundled together and added to the blockchain. A node is a computer that keeps a copy of the blockchain and helps validate transactions. Decentralized means that no single person or company controls the system. It's managed by many users. A hash is a unique code that identifies a block and links it to the previous one. A ledger is a record of all transactions on the blockchain. A token is a digital asset built on the blockchain, often used in apps or games. A bridge is a tool or protocol that allows you to move cryptocurrencies or tokens from one blockchain to another. A mixer or tumbler is a service that mixes different users' cryptocurrencies together to make transactions harder to trace. So we look at cryptocurrencies and the potentials for criminal exploitation, or the ways we know criminals are exploiting cryptocurrencies. We have decentralized digital transactions. Cryptocurrencies enable fast, borderless transactions without central authority oversight, transforming the financial landscape. And some of the risks involved are digital currencies are exploited for theft, fraud, money laundering, and ransomware due to their pseudonymous nature. Challenges for law enforcement: the lack of central control complicates tracking and reversing illicit crypto transactions, challenging enforcement agencies. And there is a need for global cooperation, so mitigating crypto-related crimes requires robust investigative frameworks and international collaboration. The distribution of cryptocurrency crime reveals distinct patterns that inform investigative priorities and resource allocation. Sanctions-related transactions represent the largest category of illicit activity, accounting for approximately 33% of the volume. This includes activities by sanctioned entities attempting to evade economic restrictions through digital assets. Blocklisted addresses representing known criminal entities comprise of 29% of illegal activity, while fraud and investment scams account for 18%. Ransomware attacks have emerged as a particularly concerning trend, with payments reaching record highs, despite overall illicit activity declining in some categories. The surge in ransomware demonstrates criminals' increasing sophistication in leveraging cryptocurrency for extortion schemes. Darknet markets continue to represent a smaller but persistent segment of 5%, while terrorist financing through digital assets has expanded to 3% of total illicit activity. Modern cryptocurrency criminals employ increasingly sophisticated obfuscation methods to evade detection. Cross-chain crime has surged past $21 billion, with investigations revealing that 33% of complex cases involve more than 3 blockchains, 27% involve over 5, and 20% span more than 10 different networks. This chain-hopping behavior creates significant challenges for investigators who must trace funds across multiple blockchain ecosystems with varying technical architectures and investigative tools. North Korea alone accounts for approximately 12% of cross-chain criminal activity, with state-sponsored groups like Lazarus employing advanced techniques following major hacks such as the record-breaking $1.46 billion Bybit incident. These actors demonstrate remarkable sophistication in using bridges, mixers, and decentralized finance protocols to obscure transaction trails. So let's take a look at some of the foundational investigation methodologies. The foundation of cryptocurrency investigation lies in the blockchain analysis, the systematic examination of transaction data recorded on distributed ledgers. Unlike traditional finance investigations that rely on obtaining records from centralized institutions, blockchain investigations leverage the inherent transparency of public blockchains where all transactions are permanently recorded and publicly accessible. Address clustering involves grouping cryptocurrency addresses that likely belong to the same entity based on transaction patterns, timing, and behavioral indicators. This technique is crucial for mapping the true scope of criminal operations that may span hundreds or thousands of email addresses or of wallet addresses. Transaction flow analysis enables investigators to follow the money by tracing the movement of funds through multiple addresses and intermediary services. This process often reveals cash-out points at regulated exchanges where criminals attempt to convert cryptocurrency to traditional currency, providing opportunities to obtain Know Your Customer or KYC information. And we also implement digital forensics and wallet analysis. So we use digital forensic techniques to extract wallet files and recover private keys from devices seized during investigations. Cryptocurrency investigations benefit significantly from open source intelligence techniques that link blockchain activity to real-world identities and operations. OSINT methods include analyzing social media profiles, forum posts, and dark web communications to identify wallet ownership and criminal networks. Investigators regularly examine publicly available blockchain explorers, social media platforms, and cryptocurrency forums to gather attribution data. The integration of OSINT with blockchain analysis creates powerful investigative capabilities. For example, investigators can link cryptocurrency addresses found in social media posts to transaction patterns, revealing criminal networks and operational methods. This multi-source approach significantly enhances the effectiveness of the investigation. Although the blockchain is pseudonymous, not truly anonymous, OSINT can help link wallet addresses to real people by looking at transaction patterns, so repeated behaviors or timing. Wallet reuse, using the same wallet across platforms, can expose identity. Metadata and IP leaks, information from exchanges, forums, or leaked data can connect wallets to users. And the use of bridges and mixers. Bridges move assets between blockchains and may leave traces. Mixers try to hide traces, but patterns can still be analyzed. So then we move into the advanced investigations. The cryptocurrency investigation ecosystem relies heavily on specialized blockchain intelligence platforms that provide sophisticated analysis capabilities across multiple blockchain networks. These platforms have expanded rapidly in recent years, with leading providers now supporting dozens of blockchain protocols. The integration of artificial intelligence into cryptocurrency investigations represents a significant advancement in analytical capabilities. AI-powered platforms can analyze vast data sets to identify previously undetectable patterns and behavioral signatures associated with criminal activity. Machine learning algorithms excel at detecting anomalous transaction patterns that may indicate money laundering, fraud, or other illicit activities. These systems can process millions of transactions in real time, flagging suspicious activity for human investigation. Advanced AI systems can also predict potential future criminal activity based on historical patterns and behavioral analysis. Natural language processing techniques are increasingly used to analyze communications associated with cryptocurrency addresses, such as social media posts, forum discussions, and dark web marketplace listings. This capability enables investigators to build comprehensive profiles of criminal operations and their participants. Mixer and tumbler analysis. Cryptocurrency mixers and tumblers represent a significant challenge for the investigators, as these services are specifically designed to obfuscate transaction trails. However, advanced analytical techniques have been developed to penetrate these obfuscation methods. Investigators analyze mixer operations by examining input and output patterns, timing correlations, and behavioral signatures that may link mixed funds to their original sources. Even sophisticated mixing services often leave detectable traces through transaction amounts, timing patterns, or technical implementations that can be exploited through careful analysis. Recent law enforcement actions have demonstrated the effectiveness of these techniques. The Tornado cash sanctions and subsequent investigations revealed extensive usage patterns. Decentralized finance protocols represent unique and investigative challenges due to their automated smart contract-based operations. Criminals increasingly exploit DeFi protocols for money laundering through techniques such as liquidity pool manipulation, flash loan attacks, and cross-protocol asset swapping. Investigators must understand the technical mechanics of various DeFi protocols to effectively trace funds through decentralized exchanges, lending platforms, and yield farming operations. This requires specialized knowledge of smart contract interactions, automated market makers, and liquidity provision mechanisms. Advanced DeFi investigation techniques include analyzing smart contract code for backdoors or vulnerabilities, tracing governance tokens distributions, and examining liquidity pool contributions and withdrawals for suspicious patterns. These investigations often require collaboration between technical experts and financial crime experts. Non-fungible token NFT investigations require specialized approaches that combine traditional financial analysis with digital art and collectibles expertise. NFT-related crimes include wash trading, pump and dump schemes, intellectual property theft, and money laundering through high-value digital assets. Investigators analyze NFT marketplaces to identify suspicious trading patterns, such as rapid price increases followed by immediate sales, or circular trading between related addresses. These patterns often indicate market manipulation or money laundering activities disguised as legitimate art transactions. The relatively low liquidity of NFT markets compared to cryptocurrency markets makes them less attractive for large-scale money laundering, but criminals still export NFTs for specific purposes. Investigators must understand both the technical blockchain aspects and the cultural dynamics of NFT communities to effectively investigate these crimes. So some of the technical challenges that investigators can face are privacy coins such as Monero and Zcash employ advanced cryptographic techniques that make transaction tracing extremely difficult or impossible. Law enforcement agencies are investing in research and development of new analytical techniques to try and address these privacy technologies. There's layer 2 scaling solutions that introduce in additional complexity by moving transaction activity off-chain or to specialized protocols with different analytical requirements. Investigators must adapt their techniques to handle Lightning Network transactions, state channels, and other scaling solutions that may obscure transaction trails. And then one that I feel that we've been talking about for quite some time now is quantum computing. Represents a potential future challenge to cryptocurrency security and investigation techniques. While still theoretical, quantum computers could potentially break current cryptographic protections, requiring fundamental changes to both cryptocurrency systems and investigation methodologies. So some of the emerging threats and opportunities that we see before us. So artificial intelligence, as we know, represents both an opportunity and a challenge for the investigations. While AI tools can enhance analytical capabilities and automate complex investigations, criminals may also leverage AI for more sophisticated attacks and evasion techniques. The development of AI-powered investigation tools must keep pace with AI-enhanced criminal capabilities. And then decentralized autonomous organizations, DAOs, and advanced smart contract systems may create new categories of cryptocurrency crime that require novel investigative approaches. Investigators must develop expertise in decentralized governance governance systems, automated protocol operations, and complex smart contract interactions. When we talk about crypto investigations, we often talk about asset recovery and can we recover the assets. It is one of the most challenging aspects of a digital asset investigation. Unlike traditional assets, cryptocurrencies exist only as cryptographic keys, making physical seizure impossible without obtaining the private keys or controlling the wallet infrastructure. Law enforcement agencies employ several strategies for cryptocurrency seizure. Exchange-based seizures are the most common, involving cooperation with regulated cryptocurrency exchanges to freeze accounts and seize these funds. These operations require proper legal process, as David mentioned in some of his examples earlier, and coordination with exchange compliance teams. Direct wallet seizures occur when investigators obtain private keys through device seizures, court orders, or voluntary surrender. These seizures require specialized technical expertise to ensure proper handling of cryptographic materials and maintain chain of custody for legal proceedings. Smart contract-based freezing has emerged as a powerful tool for certain types of digital assets. Stablecoin issuers can freeze specific tokens through smart contract functions, effectively immobilizing funds even when private keys remain unknown. This capability has proven particularly valuable in large-scale fraud investigations. So some quick case studies from the investigation side. These recent case studies demonstrate the evolution and effectiveness of the cryptocurrency investigation techniques. The Intel Broker investigation showcased how blockchain analysis combined with traditional investigative methods can identify sophisticated cybercriminals operating across international boundaries. Law enforcement used controlled cryptocurrency purchases to obtain transaction data, which was then analyzed using advanced blockchain intelligence tools and OSINT to trace the suspect's real identity. The Colonial Pipeline ransomware case remains a landmark example of successful cryptocurrency recovery. FBI investigators traced the ransom payment through multiple blockchain transactions, identified the ultimate destination at a cryptocurrency exchange, and successfully recovered a significant portion of the funds through legal process. This case demonstrated that even sophisticated cybercriminals cannot fully exploit cryptocurrency anonymity when facing determined investigation efforts. And then finally, the Philippines kidnapping case illustrated how blockchain analysis can support investigations of violent crimes involving cryptocurrency payments. Investigators used transaction analysis to trace ransom payments through multiple intermediary addresses, ultimately identifying key participants in the criminal network and facilitating successful prosecutions. So some key takeaways. Cryptocurrency investigations have evolved from simple blockchain analysis to sophisticated multidisciplinary operations requiring advanced technical tools, international cooperation, and specialized legal frameworks. The success of these investigations depend on several key factors: investment in advanced analytical tools, development of specialized expertise, establishment of international cooperation mechanisms, and the creation of appropriate legal and regulatory frameworks, again, as per the timeline and roadmap that David showed earlier. For organizations developing cryptocurrency investigation capabilities, several recommendations emerge from current best practices. Technical infrastructure should prioritize platforms with broad blockchain coverage and advanced analytical capabilities. Personnel training must encompass both technical blockchain analysis skills and traditional investigative techniques. Legal preparation requires understanding of rapidly evolving regulatory frameworks and asset tracing procedures. International cooperation capabilities are essential for addressing the global nature of cryptocurrency crime. Organizations should establish partnerships with international counterparts and participate in information sharing networks. Public-private partnerships with cryptocurrency service providers can provide valuable intelligence and enhance investigation effectiveness. So looking to the future of cryptocurrency investigations will likely see continued technological advancement, closer international cooperation, and more sophisticated criminal evasion techniques. Success will require ongoing adaptation, investment in new technologies, and maintenance of specialized expertise across technical, legal, and investigative domains. As cryptocurrency adoption continues to expand globally, the importance of effective investigation capabilities will only increase, making this field a critical component of modern financial crime prevention and enforcement. Thank you for your time.
Thank you very much, both of you. That's really great, fascinating stuff. So, Steve, obviously my head is buzzing with questions for you because I've just heard your presentation. So sorry you're not getting a rest immediately. Could you give me some examples perhaps of international cooperation? Is that happening at government level or just really business to business level?
Business to business and law enforcement level. So we are getting cooperation with Interpol, FBI, as well as local law enforcement. It's becoming more and more a global issue because of where the exchanges reside, how many exchanges or wallets that the money can pass through. So that cooperation is key.
Yeah, thank you. So give me some examples of where you've been involved in international cooperation, can you?
Trying to think. You put me on the spot there.
Well, while you're thinking about, oh, sorry, carry on.
No, I was just going to say the ones that I've dealt with have been mainly on the back of incidents and tracing cryptocurrency after ransomware payments. So there is law enforcement cooperation involved in that.
Right. And is that, was that in Europe or whereabouts were you?
I mean, yeah, some of them were European based ransomware investigations. And then I've dealt with some as well in the States, where there's an organization is multinational, and so there is cooperation from different sets of law enforcement partners.
Thank you. And David, you talked mainly about all these fascinating cases, and I would like to hear more about some of those. But when you look at the regulatory framework in the UK, do you think that with or without specific legislation, and of course you can debate how useful that is, do you think the UK has moved quickly enough to seize the opportunities created by digital assets?
Not particularly, no. There are jurisdictions that have moved lightning fast by comparison to what the FCA is, the FCA's approach. I mean, we do tend to be a kind of halfway house between the swashbuckling jurisdictions of the United States and Singapore and UAE, where wealth creation is and opportunities and seizing opportunities for wealth creation is the most important metric to success. Whereas here, we are probably more towards the European culture of regulation and consumer protection. And I think the FCA probably has had more with the individual investor and the individual investor's protection in mind than the kind of innovative, fast transaction, hyper-fast transaction sort of stuff that other jurisdictions have done. We just are, frankly, just more prudent. We're not quite as bad, I think, as maybe the EU. Although the EU, of course, has established its own regulatory framework at the moment, although that's developing. My expectation is that when the FCA, given the nature of the City of London, in particular, what is still a major financial centre, I expect there to be a kind of a big bang moment, and that big bang moment could be in the middle of next year when the stablecoin regulations are likely to come into effect, and of course when the new ETN note system is also brought into effect, and people can don't have to invest directly into crypto, but they will invest in funds that hold crypto, and it'll hold the right kind of crypto from an investor's point of view. And I think we're going to see considerable movements of money over the next 2 years. And that's probably why the FCA are being as slow as they are. They can see that, once you get the institutional investors in, the sums are going to be eye-wateringly huge.
Yes, although they possibly could have been much huger if the UK had moved more quickly. But we seem to have had in the UK quite a respectable looking set of stablecoin regulations. They've been around for a few months. Why are they only going to be implemented in the middle of next year?
Well, I don't represent the FCA, and they are a public body. They are a regulator, an authority, an emanation of government. Civil servants are not known for their radicalism, nor I think does this government have the political will to drive that particular bandwagon forwards at hyper speed. They've got other priorities. Keeping the existing bandwagon on the road being one of them. So I can't answer that question because I don't know. All I can say is that they are consulting. There are a lot of stakeholders. There are a lot of big players here in the city, and I expect they all want to input into it. I mean, this is still, relatively speaking, a very new area and a very new kind of financial service, financial product. And it's just not in the nature of this particular regulator to work to move quickly just for a few dollars more. I mean, they've probably got the bigger picture in mind, I suspect.
I mean, what I'm seeing, for example, in Hong Kong is that there's considerable amounts of funds flows, for example, between this part of the world and Africa. A lot of trade flows are actually now going in USDT. Not for any nefarious reasons, simply because the banking systems across those jurisdictions, particularly at the Africa side, are not very efficient. And so being able to have funds arriving in 10 minutes, literally, for a transaction is a huge benefit to trade. And do you think that's a vision the UK would share, to have, fiat-based, pound-based sterling?
Well, I think a lot of people, I would be interested to know what the ratio between the investors who invest and use the currency, use it for long-term investment and sit on it and realize it when they need it. But otherwise, there is this kind of, I think there is a kind of culture of not so much trading as waiting and seeing, because everybody thinks the price of the Bitcoin is going up. It's volatile, but it goes up. And how much of it is actually being used for transactions and day-to-day transactions. I mean, I've been involved in property purchases, and there are the odd ones in my jurisdiction that go through. I don't think, given the nature of our kind of sanctions environment, given the nature of where we are in the SWIFT network and all that, I don't think we're not using, in the West generally, I don't think we're using crypto to remit funds in that way. Is my feeling. It may be more in Asia. It may be far more common than it is, I think, in the West.
I think it's the particular example of USDT for some types of that I personally have seen for some kinds of trade payments, and that is certainly being a major factor of the stablecoin legislation we now have in Hong Kong. And it seems that the US is basically going to create a very vibrant framework for stablecoin issuance. And I could see that in 2 to 3 years even, meaning that a lot of trade payments within the US are going to be made in stablecoin. But you don't particularly see that on the immediate horizon in the UK.
I think the aim is there, but I don't see that as the primary driver of regulation at the moment.
Yes, it's much more on the investor protection side, is it, even for stablecoin? Steve, back to you. we often hear that it's said, oh, the blockchain is actually quite a safe mechanism for recording assets because it's indelible. But do you think that actually helps when it comes to the sort of work you do, or do you think actually the nature of it means assets can move so fast from one place to another that that sort of negatives this in so-called indelible footprint that may have been left behind?
I think, again, from with my investigator hat on, while the assets reside in the blockchain, you can trace it and you can track it. As soon as they're removed from the blockchain, and it can disappear. I mean, I mentioned about tumblers and mixers that can also, add an element of confusion, and have done in previous investigations. Um, but yeah, while you can see hops and see assets moving from one wallet to another through the blockchain, yeah, I think it's definitely an asset.
So what do you think in terms of the use of AI? Because AI has sort of come on leaps and bounds, even in the past 12 months, hasn't it? Are you using AI in your own investigations? I mean, it must be hard to keep up with the capabilities that it's kind of introducing.
It is, and it's the same in incident response investigations as well. Threat actors are starting to use AI to conduct ransomware attacks or phishing attacks and things like that. It's the same with criminals in crypto cases. They're using AI to automate laundering and transaction obfuscation. But us as investigators also benefit from AI for the real-time fraud detection, smart contract auditing, and the behavioral profiling. There's there's a lot there that can be said that can help both sides. And staying ahead of the game is key. And these tools allow the forensic team to detect anomalies and trace funds quickly, and so we're always trying to stay that one step ahead.
Yeah, I thought it was fascinating when you were talking about analyzing patterns using AI. Can you just give a couple of examples of how exactly you would do that?
So we utilize a number of tools, but what you can generally see is you see spikes of activity into a wallet, or you see spikes from one wallet to another across time periods, and analyzing those patterns, and using AI to identify those patterns takes the manual work out of it. But you then have a pointer or a starter for 10 going, well, this is abnormal behavior, or this is not, this wallet hasn't had anything paid into it for 12 months, and then all of a sudden you've had 10 transactions within 3 days. So those kind of spikes in activity is what we're looking for.
Right. I suppose some of that comes from traditional real world types of investigation, some of those concepts as well.
Exactly. It's all the same. In an incident scenario, if a threat actor had gained access to an environment through one single PC, we would look at that PC and look at the spike in activity, and if they'd used a dormant admin account that hadn't been used for a long time, or it was an account that belonged to a leaver that hadn't been deleted. You can identify these spikes in activity that the threat actor is moving through a system.
So I found it really interesting when you were talking about NFTs and you were saying that actually you have to understand the sort of NFT communities to be able to understand what might be going on there. Do you have any particular experience about investigating in relation to digital collectibles, or do some investigators even specialize in that area?
I don't. I have worked with some that specialize in that a
Right.
little bit more. It's not really my area of expertise, but again, yeah, I find it interesting like you. It's definitely an area that you have that cross section of skills, from investigation to, almost antiquities and collectibles and things like that. So yeah, it's definitely interesting. I don't know, David, if you've ever had any experience of any NFT.
Not really. I mean, the maxim that a fool and their money are easily parted comes to mind.
Yeah.
To some of this stuff, whether it's signed pictures of Donald Trump or smoking monkeys or whatever it is that NFTs. I mean, it seems to me that the NFT boom was about 3 years ago when you couldn't get away. There weren't that many cases coming before the courts, even 1 or 2 years after that, and they're usually just sort of breach of contract cases more than anything else. I feel that ship has partly sailed, but maybe, as you say, Julia, I'm not part of that community, so I probably wouldn't know.
Yeah, sometimes, these types of things, they peak and then they fall off, but then they find their place, don't they? That tends to be the history of some types of online activity. So I think perhaps the jury's still out on NFTs. So, Steve, you raised quantum computing as a threat. So how could that actually undermine current cryptographic security in blockchains, do you think, in particular?
I mean, it's a world of unknown at the moment. We've been talking about quantum computing for a long time, and the threats it could pose. I mean, there again, as with anything, any technological advancement, there's pros as well. But it's I think it's very much the same. I just think it just takes it to the next level. We've got AI and machine learning currently. I think quantum computing will take it to that next step.
If I can
sure.
venture an opinion from somebody who's not as technical as you are, Steve. I mean, quantum computing is a terminal threat to cryptocurrency because the technology, as I understand it, is firstly, cryptocurrency is based entirely on a mathematical problem that only has one kind of solution. And if you have the solution, then you basically own the asset, so to speak. Quantum computing can process and resolve that mathematical problem near instantaneously in what would otherwise take a million years to resolve using traditional computing techniques. So if you completely solve the mathematical cryptographical problem on which the whole technology is based in moments or minutes, the whole thing unravels. So it is going to depend on how effective this technology is. And we know that there are, I mean, obviously the maths and the algorithm and the design of the computers is fairly settled. I think they are being manufactured in small scales at the moment. It is just a matter of time, I suppose. If that does then resolve the mathematical problems on which all this is based, you're going to have to use quantum computers to generate new quantum mathematical problems. And then I suspect strongly you're going to have to create entirely new blockchain ledgers and techniques to accommodate it.
Force multipliers, yeah. Can we talk about DAOs for a minute? Do you ever come across DAOs in any of these fraud cases you were involved with, David?
Sorry, who?
DAOs, decentralized autonomous organizations, which are the voting block.
Well, yeah, I mean, the obviously the Tulip trading case was directed at the development community of Bitcoin, who are fairly enormously, these days, quite enormously powerful, even though they are fintech, really highly specialist people who believe strongly, I think, in the anonymity and the rights of the individual. They have they do have a sort of political agenda in addition to their own interest in this field, and just by nature of how this whole sector has developed, they've been landed with a great deal of power, and that they are effectively in this case, they are effectively an unincorporated body of
Yes.
people who are
Yes.
reposed with the authority and the technical tools to make changes to the whole basis of the crypto asset. And we see that in they, I mean, effectively, they are the custodians of the line of succession of transactions. And any changes that they make, and I think this is well known, any changes that are made to the fundamentals on the blockchain, on the distributed the DLT, creates a new branch, creates an entirely new branch of the record, which some people or some users of the system may not recognize. So you end up with a branch, a split, and this split is like a tree. It can proliferate. And then, of course, you lose the distinctiveness as well as the organization, for what it's worth, the consensus that gives is one of the distinguishing features of crypto assets. So they, I think, feel that they need to preserve the lineage in some ways of what this product is, what this form of asset is. And they are fighting fairly defensively on a number of fronts. There's actions in Australia. I mean, most of it, frankly, is coming out of Craig Wright. A lot of it now, obviously, falling away with the various findings in England made against him. It's what is interesting, certainly in the Tulip trading case, is that the Court of Appeal thought there might be something to this. There might be. It is not just a question of you acting as sort of developers on GitHub producing code. You actually, there's so much involved now. There's so much money involved. There's so many people's futures, aspirations, and investments tied up in all of this, that you have responsibilities. You have legal responsibilities, and you may very well have fiduciary responsibilities to protect and defend people who are the victims of frauds that would otherwise be detectable and preventable. I mean, the good thing about blockchain technology is that the blockchain never forgets. If it's a publicly distributed blockchain, the evidence will be there. And I think somebody in the comment section with a question asked, what's easier to trace?
Yes, I was going to come on to that question in a minute. Should we deal with it now then?
Yeah, and I think in terms of tracing it, crypto, because you can tell exactly where it's been until the point that it's cashed out.
Steve, would you agree with that?
I would, and that was the point I was trying to make earlier. While assets are in the blockchain, it's a lot easier to trace.
So, do you come across DAOs at all in your investigations?
I haven't done.
Right. Because the reason I'm asking is that I see quite a lot of quite what I would characterize as sometimes quite manipulative market rigging type behavior of building up voting blocks within DAOs and so on. And it doesn't have, it has a lot of the issues which a conventional securities market would have, but none of the protections which have grown up over the years in those markets. So I find the behavior very interesting, because you think, oh yes, that's what's regulated in the ordinary capital market space.
These are all genius level IQ people with egos the size of planets.
Well, not all token holders who get involved in DAOs are genius level, I think. I mean, some are.
Oh, well, no, as a body of people, no.
Yes, they don't represent the sort of average person usually, do they? So, in terms of DeFi protocol investigations, Steve, are there particular challenges from decentralized governance? I mean, this is a question which ties in with what I was just asking about DAOs, or have you not particularly come across that?
Yeah, again, it's not something I've ventured into at the moment, I'm afraid.
Mm-hmm. So, David, when you are working on cases and so on from a litigation standpoint, do you ever see some of the documentation that relates to crypto assets?
In theory, it should be entirely open. I mean, in theory, these are open source open coded things.
The smart contracts and so on, yes, but some of the agreements that relate to it, some of the governance and so on, are those agreements?
The methodology should be produced in the white paper, and these white papers are today and increasingly drafted by very significant international law firms with significant fintech expertise. They're not just put together over a pizza, in someone's basement. This is hundreds, if not millions, of dollars worth of work go into the generation of these documents, and they are fundamental to the confidence in which an investor can place in the robustness of the cryptography, but also of the safety of the transactions. Nobody wants to be involved in parting with money and not being and not receiving something in return for it. So that we do see, and there's a certain amount of open information in addition to the blockchain itself that we do see. But as ever, vested interests will keep some things under wrap.
Yes, I mean, I see quite a lot of agreements, and some of them are quite inconsistent and, overlapping jurisdictions and so on. But I suppose as the industry matures, we'll see more and more standardization of documentation. I'm talking about agreements for tokens.
Well, I mean, you could have sort of ISDA kind of.
I was thinking that
at some point.
At some point in time, yes. So here there's a question from a participant. How do compliance obligations and pegging arrangements differ when a digital asset is pegged to fiat versus when it's pegged to gold, given the different volatility profiles of both? I think that's a fairly mathematical question, actually.
Obviously beyond the scope of just what was a case law update, but in terms of regulatory position, part of the stablecoin regulatory drafting in England, at least, involves a certain amount of prudential management. So it involves the way stablecoins operate is that they are supposed to have on deposit a certain capital ratio of actual fiat or whatever commodity that is being utilized to be pegged to. They're supposed to have a certain amount of gold, literally, somewhere on deposit, or certain hundreds and hundreds of millions of dollars. And this is one of the reasons that the Friedman Banks litigation happened, and the criminal case in the US happened, is because they didn't have the on deposit, or they weren't, they were spending instead of having what was needed from a prudential management point of view. And so in the UK, that's partly down to the FCA's regulations, and it's going to be probably partly down to the Bank of England, who sets the prudential capital ratio requirements in our jurisdiction. So if you will, it's going to be interesting, because if you want, it could be that different jurisdictions differ as to what they require from a regulatory point of view to be held by the coin operator. And it may be that you effectively have to have different branches of the same kind of branded coin, but different branches for different jurisdictions, because there's no consistency between the cross borders.
I think they'd be separate coins because they wouldn't be fungible. But yes. So actually, we're already at the end of around about 90 minutes. So thank you both so much. Just as a final question, Steve, in your area, what would you see developments in the next year or so being? And David, perhaps the same for you. Steve?
We'll continue to see technological advancement. I think, I'm hoping we'll see closer international cooperation as well. With that technological advancement, there's obviously going to be enhanced criminal techniques. Like I've previously mentioned, we just need to try our best to stay ahead of that.
Yes. You've really highlighted to me the other side of the coin, that AI is one thing in the hands of good actors and another thing in hands of bad actors. Yeah, we have to remember that. David, what do you think?
I would like to see somebody take up the cudgels on the tulip trading principle of the fiduciary responsibilities
Yeah,
of the
fascinating.
developers.
Yes,
I
yeah.
don't think that case is going anywhere. In fact, I've got my own personal suspicions that it's been settled confidentially, but I don't know who's involved. That will probably it just needs the right fact pattern to come along and for that to then be kicked off again. I think there's scope probably for some international treaty to govern and regulate how different jurisdictions recognize each other and maybe to assist and to facilitate the kind of problem that I've just highlighted about different prudential requirements for stablecoins in particular. Yeah, I think the one point I make about that is that if one looks at the beginnings of cryptocurrency, if one looks at the motives and the agendas of the people that developed it and are developing it still, that is inimical to the idea that it should be regulated or there should be international treaties or anything of that nature, because this is supposed to be very much putting all the power in the hands of the individuals and escaping the clutches of the regulator. And that really was the purpose. It may now be that it's got too big and all of those fine ambitions need to be set to one side. But that was certainly the starting point.
Yeah, it certainly was a big strand and continues to be amongst some. Well, thank you both so much. So I'll just wrap up now and thank our fantastic panelists, Steve and David, for all their very generous time and sharing their expertise. And it's been great to hear from you, Steve, on the Wild West of crypto assets and blockchain technology. And David, fascinating to have an overview of all the English case law. I mean, that's rare to get that all in one place. And we've heard what all the things we've got to look forward to in the UK in 2026 with stablecoins and so on. So that should be a great year for the UK. And we've heard a lot about AI and how it's revolutioning not only investigations, but also criminal activity, which I guess we need to remind ourselves of. So I guess staying adaptable is going to be key. And thank you all for joining us very much, as well as thank you again to these wonderful two speakers. So this brings me to the end of this Legal Link webinar. Thank you so much for joining us. Thank you very much. Bye, everybody. Bye.
Thank you, everyone.